Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. What's good, y'all? It's your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey, y'all, let's get into this WACK 100 divorce. As you guys know, the rumor out there is Miss Kimberly Jones filed for divorce against Mr. Cash Jones, aka WACK 100. And I guess everybody but me knew that she previously filed back in 2012. So that's the case that we're going to tap into right now. Now, 2012 to 2025, some years have passed, which means that some things have changed. So she can't base this divorce off of what she initially filed in 2012. She's going to have to make some changes, and that's what we're going to tap into in a couple of seconds. But I do want to show you guys the court docket for this particular case. Now, at the time, 2012, when she initially filed, they did have minor children. And the petition that was filed and the supplemental documents that goes with it pretty much outline, the custody, child support, so on, so forth when it comes to the minor children, any separate property, community property, so on and so forth. But like I said, it's 2025. Property value has gone up. Kids are grown. So she can't use that same petition that she used initially in 2012. So it has to be updated. So there have been a series of events that has happened since 2012. So let's see. Once again, she initially filed on June 18th of 2012. She submitted all the documentation that she needed to, custody, child support fees, so on and so forth. She submitted her income and expense report, all of that good stuff. This was all served to WAC 100. He was actually served. I don't know exactly when he was served, but the proof of service was filed July 10th. He was supposed to answer. When I say July 10th, that's July 10th, 2012. Okay. So once you are filed a lawsuit, you have to answer to it. He failed to answer. So what did she do? She put in a request for a default judgment on September 5th, 2012. Okay. 2012. They then sent another notice to WAC and say, hey, you ain't respond, a default judgment is going to be entered. She put together her judgment package. Let's see. She submitted one December 31st, 2012, and another on February 1st, 2013. Now, what happened between 2013 and 2015 is unknown. Maybe they worked it out because from what I knew, they were still together. And so they didn't notify the court. And so the court kind of put the case dormant or inactive. That's a better term to use. So the case was inactive because they failed to file a dismissal, right? Now, speed up all the way to 2025. In July, a request for a dismissal was filed by Kimberly. I don't know what happened to that, but I'm sure that it wasn't granted because of the documents that they filed on September 12th, 2025. Now, she did substitute her attorney, meaning that she probably got a new attorney. But there are a couple of documents that we're going to go over that shows you her amended petition, her motion to do some things and request the court to do some things so that way she can update the petition, so on and so forth. And then there's also a statement in there, and I'm going to read that to you guys towards the end of this video. But let's hop right on into the three documents that they filed. So this is the amended petition. But before you do anything, you really have to file, what is this called? The motion. So I'm going to put these in order. So the first thing that I'm going to show you guys is the notice of the motion and the motion to set aside suspension to restore the case to active status because right now it's not active. Okay, so I just want everybody to be clear. Kimberly did not file or refile for divorce, what she did is she submitted a motion to activate the case, to get it to active status so that way she can file her amended petition with the changes because years have passed. And then she's also, I think because WAC 100 did not respond, she's trying to set aside uh, the suspension. Okay. So it's like they're starting all over. So once again, once that amended petition is filed, if the court grants the leave for her to be able to file that amended petition, then it will be served to WAC. WAC has to respond. Hopefully he will respond and then they can get on with the case. Right. All right. So in this particular motion, oh, let's see. Da, 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 da. So, setting aside the suspension that was entered on January 5th of 2016 and restoring this case to active calendar status, they want to grant the leave to file a first amended petition for the dissolution of marriage and whatever other relief the court deems just and proper. Now, the reason why they motioned this court, as I stated before, material circumstances have changed since the case was inactive since 2016. And we have to think about it. As I stated, the kids are now grown, they're not minors. Any community property, if they, or yeah, community property, so if they share a house or a land, all of that has gone up in value, right? If, spousal support, if she's requesting that, I'm pretty sure WAC 100's value net worth has probably gone up and she's requesting more. So those are the material circumstances that have changed over the years. Let's see, the party's petition was filed in 2012 and it is now over 13 years old and no longer accurately reflects the party's circumstances. All minor children have reached majority, eliminating child support and custody issues. Substantial community property requires proper adjudication and management. So they do have to oversee because, boy, I really, really think that this is not going to go as easy as some people may think. I'm dealing with a couple of family law cases, and these not even celebrities, and it is wild. Okay, so Kimberly gonna come for all of hers. And then the interests of justice require restoration of the case to active status for proper resolution of community property rights. So this is just a motion. It has to be heard. And if the judge grants it, then they will restore the case and then she'll be able to file the amended petition. Now, I'm not going to read, let me see. Yeah, I'll probably, well, yeah, let me go to the petition. So, this is the amended petition that she's wanting to file. So, legal relationship, yes, they are married. They both have lived in the county for at least 6 months. Well, in the state for 6 months, in the county for at least 3 months prior to the filing of the petition. Oh, this is crazy. They were married June 30th, 2000. Baby, I was a freshman in college. They separated May 15th, 2024. So they've been, well, it says the time from date of marriage to the date of separation, 23 years and 10 months. Good googly moogly, was married for a long time. There's no minor children. Mind you guys that this is the amended petition. So there's no minor children. They're divorcing because of irreconcilable differences. Let me see. What else? She's asking for spousal support. A complete inventory of all separate and community property assets and obligations of the party shall be set forth on the property declarations to be filed by a petitioner. So they're going to have to list out every single asset that they have, whether it is their sole separate property or whatever they got during the marriage. So anything that both of their name is on, that's community property. Anything that was gifted to him or her by the other individual, that's considered their separate property. But anything that's both their name is on, that's going to be community property. And there's going to be a fight of percentages on that. I best believe that. Um, determine rights to community. And here's the kicker. If they can't agree on who gets what out of that community property, then the court is going to determine that. And that's what you don't want. It could get nasty. It could get really, really ugly on this one. She's also asking for her attorney fees to be paid, attorney fees and costs, and she wants to go back to her name, Kimberly L. Ross. She ain't playing no games, baby. She's like, I don't want this man's last name. Give me back my maiden name. So the cool thing about this is it's rather quick. They have a hearing on November 5th at 8:30 a.m. and they are going to go over this motion that I am about to read to you guys. So this is the motion to set aside the suspension, activate the case, so that way she'll be able to file her petition to amend, well, her amended petition in the court for divorce. So this is going to be very, very interesting. Very interesting case. All right, so going on to the procedural history or procedural background, I said history. Uh as I stated before, the dissolution proceeding was filed on, what is that, June 18th, 2012. The case was suspended on January 5th, 2016, and remains on suspended status. So whether I said inactive or suspended is still the same thing. It is dormant. It's not moving anywhere. No action is being done. Here's some recent developments. On June 11th, 2025, petitioner attempted to dismiss the petition with an expectation to refile. On July 15th, 2025, the request for dismissal was denied. The court ordered case to remain in suspended special status with existing orders in place. I wonder what existing orders there are. Changed circumstances now require restoration to active status for proper case resolution. All right, so let's go for the grounds. So here are the grounds for setting aside their suspension. So when you are filing a motion and requesting the court to do something, you do have to, what is the simplest term I could say? You have to use case law to back it up. So here, why should the court set aside the suspension? The attorney listed this: courts inherit power and discretion. So the court has the power to provide for orderly conduct of proceedings. The court may control proceedings in furtherance of justice. The court may relieve party from order where circumstances warrant. Suspension was administrative in nature and may be set aside when justice requires. And it doesn't have the other part. So meaning that the court does have the say so to restore a case if it was set aside by the court. Okay. They have continuous jurisdiction over the community property. Um, the material change in circumstances since the suspension. So, as it stated before, the children have reached majority. They are no longer minors. So that way, they can go ahead and eliminate anything that has to deal with child support, child custody, visitation, so on and so forth. None of that is applicable at this time. So that takes care of some of the complex things when you are involving children in court cases, okay? The only thing that they have to focus on is property, the division of the property. Now, other material changes, the community property development. So substantial community property assets identified require court supervision. vintage automobile collection with significant value need proper valuation and management. Real property interests require updated legal descriptions and current valuations because they may have a house and, you know, when was this divorce filed? 2012. Let's say 2020, they had additions to the house. They have to update those legal descriptions and that value of that property, I'm sure since 2012 has gone up significantly. All right. So they have to be able to look at this and determine what the value is in order to see how much interest each party has in that property. And then it also states that financial circumstances have materially changed over the years of suspension. Case management necessity. Original petition was filed over 13 years ago and no longer reflects certain circumstances. Updated financial disclosures and property schedules are required because the ones that she submitted back in 2012 is not going to be the same ones that she submitted in 2025. So they can't go off of that. And then proper adjudication cannot occur while the case remains suspended. So you can't do nothing if the case is still inactive. All right. Um, they have to have their due process. Due process rights require proper adjudication. The 14th Amendment guarantees that no person shall be deprived of property without due process of law. Petitioner has vested community property interests that cannot be extinguished without proper judicial proceedings. While the case remains suspended, petitioner cannot obtain court orders necessary to protect, preserve, or adjudicate her community property interests. I'm sure that if this case does go inactive, there are going to be temporary restraining orders and temporary orders for WAC not to pull money out the account or, kick her out the house, whatever the case may be. They have to put in these temporary orders so that neither one of them can do anything to jeopardize the case. Okay. Um, Judicial economy favors restoration over dismissal and refiling. This case has a 13-year procedural history, established case number, and existing orders that provide foundation for efficient resolution. New filing would require new filing fees, service costs, and restart of all procedure deadlines. Further, current case file contains valuable procedural history and prior orders that will be lost with dismissal. Because if this case was dismissed, she would have to start over and that's not what they want. So obviously there are some things that are already in place, but it just needs to be updated to reflect what's going on in 2025, not 2012. Protection of property rights require active case status. Community property, particularly vintage automobiles, may require ongoing maintenance, insurance, and protection that needs court supervision. Active case status may be necessary to deal with creditors, insurance companies, or other third parties affecting community property. Property values change over time. Active case allows for updated valuations, proper accounting. Finally, active case status enables formal discovery procedures to identify and value all community property. Once again, as I stated before, all the property has rights. Even each party has rights. So we can't say, if Kimberly is paying for an insurance on WAC100's car, she can't go and take the car off of that. So if this case becomes active, once again, temporary orders or temporary restraining orders will be put in place. So neither one can just say, okay, I'm taking you off of this, or I'm pulling all the money out of this, or I'm taking a car, I'm kicking you out the house. All of that has to be in place so that way this community property can be evaluated and split as the court deems just and proper. Okay. And then it talks about the grounds to leave to amend the petition. So pretty much what it's saying is that the court should allow for the petition to be amended if the case does go into um an active status. All right. That's the right thing to do. I'm not going to go over that because we already talked about the minor kids and the community property and all this other stuff, but I want to get into what she stated. Now, this is the declaration of the petitioner, Miss Kimberly Jones, in support of her motion to get the case out of suspension, be able to file her amended petition and carry on with the case. It reads, I am familiar with the facts of this case, and if called as a witness, I could and would testify competently thereto. I was married to respondent on June 30th, 2000. We separated on May 3rd. Oh, wait. We separated on May 30th, 2012, and this dissolution proceeding was filed on June 18th, 2012. This case was suspended on January 5th, 2016. On June 11th, 2025, I attempted to dismiss the case with the expectation of refiling for dissolution. On July 15th, the court denied my request for dismissal and the court ordered that the case was to remain in suspended status with existing orders remaining in place. Therefore, in order to proceed with the divorce, I am asking the court to restore this case to active status rather than seeking dismissal. I am also asking the court for leave to amend the petition as there has been numerous changes since the filing of this initial petition. Both of the children referenced in the original petition have now reached the age of majority. Therefore, there are no longer any issues regarding child custody, visitation, or support. During our marriage, we acquired substantial community property, including real estate and valuable personal property. We own a family townhome at where I currently reside. We also own real property in was at Quartz Hill, California, where respondent resides, and we own a property in New Jersey that is currently in escrow, and the funds anticipated to be received from the sale are community property funds. We acquired a valuable collection of vintage automobiles during the marriage, including vehicles with individual values exceeding $100,000. The total value of our community property assets has changed significantly since 2012. Our community property requires proper valuation and adjudication. We need court supervision to ensure proper management of division of assets. The case cannot be properly resolved while in suspended status. Our case would benefit from active case management to reach final resolution. Both my income and respondent's income and debt obligations have changed materially since the original petition was filed. The values of our real estate and personal property have changed significantly. The original petition was filed over 13 years ago and no longer accurately reflects our current circumstances. The petition requests child support and custody orders that are no longer relevant, and the property schedule and financial information is now outdated and incomplete. An amended petition is necessary to provide the court with accurate and current information. I am acting in good faith to restore this case for proper resolution. The requested relief will benefit both parties by allowing final adjudication of our community property rights. I am prepared to proceed with discovery, property valuation, and other necessary steps. Whew, all right. So, Mr. WAC 100 will be served via first class mail. Or he probably already was because that's signed September 11th. So I'm pretty sure um that he is already notified. So the only thing that we could do is we could wait till November 5th and see if they will turn this inactive case to active so that way she can go ahead and proceed with the divorce. Like I said before, divorces are not easy, especially if the individuals or the parties can't agree. It is worse when you do have children, but now that they're grown, all you have to do is property. But you would be surprised of the people who fight over property. And I get it. I get it. But that's hmm, I ain't gonna get into prenups and all that other stuff, but this is wild. And I wonder what prompted her to just say, okay, I'm done, I'm through. um Let me just let's just go ahead and get this, divorce. So y'all let me know. I'm not on YouTube. I'm not in these social media streets, so I have no clue as to what's going on. I just, happened to see an article about WAC getting divorced, and I was like, wait a minute. And then I had to do my due diligence and search and find out that she initially filed in 2012. So I didn't even know that. I honestly did not know that. So I wonder what prompted her. I mean, WAC and his antics, I would be tired of it too. I would be tired of it too. But y'all let me know what y'all think about this. Do y'all think that the court is going to grant the her the ability to get the case restored and file this petition? Do y'all think that Wack is mad? Is he mad? I don't know. Y'all leave it in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.